Hi everyone, and welcome back to the official channel of LegalEdge. Now do give me a tech check. Just let me know in the chat box whether I'm audible or not. Audible and visible too. Chal, take it. So let's start with our session, and today we'll be discussing about a very important legal update which came from the Supreme Court of India this week only. ठीक है, जहां पर सुप्रीम कोर्ट ने एक जजमेंट पास करा है विद रिस्पेक्ट टू सर्टेन ऑफेंसेस अंडर द SC/ST Prevention of Atrocities Act, and what is the relevance of public view for the purposes of offenses under section 31S and section 31R under the Act of 1989. Now, before understanding why this particular thing came into news, let's understand about what is this SC/ST Prevention of Atrocities Act 1989. मेरे ख्याल से हम में से सब लोगों ने इस एक्ट का नाम तो जरूर सुना ही होगा, है ना। SC/ST एक्ट इज नॉट समथिंग विच इज अनकॉमन टू अस। हम सब लोगों ने इस एक्ट का नाम सुना हुआ है, बट ये एक्ट है क्या और क्यों एग्जिस्ट करता है? इस एक्ट के रूट्स एक्चुअली इट लेज डाउन अंडर Article 17 of the Constitution of India, which abolishes untouchability. ठीक है, Article 17 of the Constitution of India, which abolishes untouchability. अब Article 17, which is part of right to equality under our Constitution of India, वो untouchability तो abolish करता ही है। साथ में आर्टिकल 17 provides that any disability arising out of practice of untouchability shall be an offense punishable in accordance with law. ठीक है, Article 17 says that any disability which is arising out of the practice of untouchability shall be an offense punishable in accordance with law. अब ये डिसेबिलिटी थी किस तरीके की? These disability basically referred to the social disabilities which are faced by the members of the community who were treated as untouchables. ठीक है, हिस्टोरिकली जिन लोगों को अनटचेबल्स की तरह ट्रीट किया जाता था, वो जो सोशल डिसेबिलिटीज फेस करते थे। सोशल डिसेबिलिटीज मतलब ह्यूमिलिएशन, अब्यूजेस। Social disability मतलब not having access to the main market of the village, not having access to main roads of the village or the place where they are living, right? Similarly, if there is only a single water body, then they were not allowed to access the water from that as well. These were the kind of social disabilities which are faced by the members of the SC/ST communities or those individuals who were treated as untouchables. ठीक है, अब एक्ट क्या कहता है या आर्टिकल 17 क्या कहता है कि अब अगर किसी भी तरीके की डिसेबिलिटी अराइज होती है बिकॉज ऑफ प्रैक्टिस ऑफ अनटचेबिलिटी, दैट विल बी ट्रीटेड एज एन ऑफेंस पनिशेबल इन अकॉर्डेंस विथ लॉ। एंड द लॉ व्हिच वाज ब्रॉट इनटू एग्जिस्टेंस फॉर द पर्पसेस ऑफ एनफोर्सिंग द प्रोविजंस ऑफ आर्टिकल 17 वाज द शेड्यूल्ड कास्ट एंड शेड्यूल्ड ट्राइब प्रिवेंशन ऑफ Atrocities Act of 1989. ठीक है, the law which was created for the purposes of punishing these kind of activities was the SC/ST Prevention of Atrocities Act 1989. ठीक है, तो ये इस एक्ट का बैकग्राउंड है। बट ऑलवेज रिमेंबर an important thing about the SC/ST Prevention of Atrocities Act, that under the SC/ST Act of 1989, an offender will always be a person who is not a member of scheduled caste and scheduled tribe. ठीक है? The offender under this act will always be a person who is not a member of the scheduled caste or scheduled tribe. ठीक है? And जब ऐसा कोई person who is not a member of the scheduled caste and scheduled tribe commits any kind of an atrocities against a member of the scheduled caste or scheduled tribe, that is something which is punished under the SC/ST Act. ठीक? Now, one such atrocity which is punishable under the section 5 of this act is that if any such person who is not a member of SC/ST community humiliates or abuses a member of the SC/ST community by caste-based slurs, ठीक है, या through casteist comments in a place within the public view, then such a person will be punished under section 3(1)R and section 3(1)S of the SC/ST Act. ठीक है? If any person who is not a member of the scheduled caste or scheduled tribe humiliates with the intent of or humiliates or abuses, ठीक है, humiliates with the intent of or humiliates or abuses using casteist slurs against any person who is a member of SC/ST community, that person will be punished under section 3(1) and 3(1)R and 3(1)S of the SC/ST Act, provided the act of humiliation was taking place within the public view only. But then the question comes up that what if the abuse is taking place within a private property? Okay, what happens if the incident takes place within the private property, or if the incident is taking place within the confines of the four walls of the house? तब भी क्या एक offense बन पाएगा? That was the main subject matter which was discussed recently in the Supreme Court of India in this case. ठीक है? So allegations क्या थे इस case के under? The allegations were that the accused individuals were charged with hurling casteist slurs and intimidation against the scheduled caste complainant and his wife. ठीक है? जो accused individuals say they were hurling casteist slurs against a member of the scheduled caste and his wife. कहां पे ये incident हुआ? The incident occurred inside the four walls of a residential house during an attempt to break a door lock. ठीक है? The incident occurred inside the four walls of the house, residential house, during an attempt to break a door lock. And subsequently, they were booked under section 3(1)R and 3(1)S of the SC/ST Act. ठीक है? The individuals were booked under section 3(1)R and section 3(1)S of the SC/ST Act. अब section कहता क्या है? Let's look at the offense as well. So section 3 talks about punishment of offenses, atrocities. ठीक है? So it says that whoever not being a member of the scheduled caste or scheduled tribe, इसी वजह से मैंने शुरुआत में ही आपसे कहा that someone or any person who is being booked under the SC/ST Act as an offender will always be a person who is not a member of the SC/ST community. ठीक है? So whoever not being a member of the scheduled caste or scheduled tribe intentionally insults or intimidates with the intent to humiliate a member of the SC/ST in any place within a public view. So the important portion over here is that the act of insult or humiliation should take place in any place within the public view. And similarly, if any person abuses any member of the scheduled caste or scheduled tribe by caste name in any place within the public view. ठीक है? ठीक? तो अब्यूज कर रहे हो आप यूजिंग कास्ट नेम्स, कास्टिस्ट स्लर्स, या आप इंटिमिडेट कर रहे हो, इंसल्ट कर रहे हो विद द इंटेंशन टू ह्यूमिलिएट. बट इफ बोथ दीज एक्ट्स आर टेकिंग प्लेस इन एनी प्लेस विद इन द पब्लिक व्यू. नाउ व्हाट इज दिस पब्लिक व्यू? तो एसेंशियल इंग्रेडिएंट की अगर हम बात करें ना अंडर दिस एक्ट, सो कॉन्स्टिट्यूट एन ऑफेंस अंडर सेक्शन 3(1)R और 3(1)S, द एक्ट मस्ट टेक प्लेस विद इन पब्लिक व्यू. और पब्लिक व्यू का मतलब क्या है? So the judicial definition of this term public view is that it must be a place within the public gaze, जहां पर लोगों की नजर जाती हो, जहां पर लोग देख सकते हो कि क्या हो रहा है. That is a place which will be considered as a public place. So even if a place is technically private, कि अगर कोई घर भी है, ठीक है, even if a place is technically private, it only qualifies for the purposes of this offense if public eye has access to notice what is happening there. तो घर की छत पे अगर हो रहा है, घर के लॉन में अगर हो रहा है, जहां पर सब लोग देख सकते हैं कि क्या हो रहा है, that can still be considered as a public place, right? Because the incident is taking place somewhere wherein the public eye is having an option of noticing what is happening over there. But if the act is not taking place within the public view, अगर घर की चार दीवारी के अंदर कुछ हो रहा है, तब भी क्या वहां पर एक ऑफेंस बन पाएगा? So the Supreme Court in the recent judgment stated no. ठीक है? So finding of the facts were that the FIR revealed that the abuse happened inside a private residence, not a location not a location exposed to the public. And the legal conclusion was that a residential house, when not exposed to the public eye, does not satisfy the public view requirement of the act. And the results were, the Supreme Court quashed the proceedings as essential ingredients for the offense were missing. सुप्रीम कोर्ट ने कहा कि भाई अब सेक्शन 3(1)(s) और 3(1)(r) के अंडर ऑफेंस नहीं, दिस इज नॉट मेड आउट ओवर हियर बिकॉज द इंसिडेंट डिड नॉट टेक प्लेस इन पब्लिक व्यू. सो देयर आर सर्टेन काइंड ऑफ एट्रोसिटीज under the SC/ST Prevention of Atrocities Act, which are supposed to take place at any place within the public view. And if that public view requirement is not getting fulfilled over there, what is public view? A place which is within the public gaze, or any such place wherein the public eye can notice what is happening over there, will be considered as a place within public view. So if the act of abuse is not taking place, or if the act of humiliation or insult is not taking place within the public view, the offense under section 3(1)(r) and 3(1)(s) are not made out. This is something which was made clear by the Supreme Court of India recently. And this was the important legal update for us this week. ठीक है? So I hope the topic is clear. I hope topic समझ में आया हो, judgment समझ में आया. ठीक है? Just do read about the SC/ST Prevention of Atrocities Act. That is something which is important for the purposes of your paper as well. ठीक है? बाकी that's it for today. I'll see you soon. Just take care of yourself, enjoy your day, and we'll meet soon, guys. All right? Thank you so much, everyone. Thank you so much, guys. Thank you so much. Bye-bye. Bye.